Picture this. You're driving home when those red and blue lights flash behind you. You pull over, heart racing. You reach for your phone, hit record, and the officer approaches. Then you hear it, that commanding voice telling you to shut that camera off immediately. Most drivers freeze in that moment. Most comply without question. And most have absolutely no idea they just surrendered their most powerful shield. I'm about to walk you through 4 common scenarios where law enforcement attempts to kill your recording and give you the precise language to protect yourself word for word. The law protects you far more than many officers would lead you to believe. Let's break it down. Scenario 1. The officer claims recording is against the law. You've stopped your vehicle and grabbed your phone. The officer strolls up, spots your camera, and declares with absolute authority that you need to put that device away immediately because recording police officers is illegal in this state. Most citizens hear that and believe it without hesitation. Here's the actual legal reality that changes everything. Not a single state in America prohibits openly recording police officers in public spaces. Not one. Every federal circuit court that has examined this issue has arrived at the identical conclusion. The 7th Circuit Court of Appeals obliterated this misconception back in 2012. Illinois once had a draconian law classifying recording police as a felony, carrying up to 15 years behind bars. The court struck it down entirely, ruling that criminalizing the recording of government officials performing public duties violates constitutional protections. So here are the exact words to deliver. Officer, recording police in public is protected by the First Amendment. I am not interfering with your duties. Speak these words calmly and with clarity. Repeat them if the officer persists. Do not elevate your voice. Do not engage in debate. Simply state your position and maintain your recording without interruption. Scenario 2. The officer threatens arrest. You've calmly asserted your rights. The officer doesn't retreat. Instead, he leans into your window and warns that failure to put that phone down will result in immediate arrest for obstruction of justice. This threat succeeds because most people cannot envision what happens next. You need to understand this critical fact. 7 federal appeals courts have explicitly ruled that arresting individuals for recording police activity constitutes unconstitutional retaliation. The 10th Circuit addressed this precise situation. A journalist documenting a traffic stop was physically blocked, blinded with a flashlight, and intimidated by a police cruiser driven directly at him. The court determined every single action violated constitutional protections. It was pure retaliation against protected First Amendment expression. Here is your response. Officer, 8 federal appeals courts have ruled that recording police is a protected First Amendment right. Arresting me for exercising that right would be considered retaliation. Deliver this calmly. Repeat it if aggression escalates. However, if the officer proceeds with arrest, regardless, I comply physically without resistance. But as handcuffs are applied, speak these words clearly for your recording. I am complying under protest. I do not consent to any searches. I want an attorney. Capture these statements on video. They establish the foundation for a powerful civil rights lawsuit. Scenario 3. The officer invokes departmental policy. This approach sounds impressively official. The officer informs you that department policy strictly prohibits recording during traffic stops, and failure to follow this policy justifies immediate detention. Most civilians hear department policy and assume it carries legal authority. It absolutely does not. The Department of Justice itself clarified this position in 2012. Their stance left no room for interpretation. American citizens possess a First Amendment right to record police performing their duties in public view. Departmental policies that block or discourage such recording are themselves unconstitutional. Officers cannot legally threaten or intimidate citizens for exercising this right. No police department anywhere in this nation possesses authority to override constitutional protections through internal administrative rules. Your response should be, Officer, no internal policy overrides the Constitution. The Department of Justice itself has affirmed that citizens have a First Amendment right to record police. I am not violating any law. Then, ask this crucial follow-up question. Officer, are you asking me to stop recording, or are you ordering me to stop recording? If the officer claims it is an order, I respond with, before I comply with any order, for the record, What is the lawful constitutional basis for that order? This forces the officer to either cite actual law, which does not exist to support this position, or admit no legitimate basis exists. Scenario 4. The officer suggests your phone poses a safety threat. This tactic sounds surprisingly reasonable. The officer requests you put the phone down because he cannot identify what it is, suggesting it could potentially be a weapon. This framing makes asserting your rights feel somehow reckless or dangerous. It is neither. The Supreme Court of the United States addressed this directly in Riley versus California in 2014. The unanimous decision established that cellular phones do not constitute threats to officer safety. The safety exception, permitting warrantless police action, simply does not apply to phones being used for recording purposes. Here is your measured response. Officer, my hands are visible and I am not moving. The Supreme Court ruled in Riley versus California that a phone poses no physical threat to officers. I am recording for everyone's safety. Keep your hands in plain sight. Maintain steady camera positioning. Verbally narrate your actions. For the record, my hands are on the steering wheel. I'm not reaching for anything. I am recording this interaction. Cease narration there. This verbal documentation creates an irrefutable record of your exact physical positioning throughout the encounter. 4 essential phrases for any police encounter. First, am I free to leave? Ask this early, and it establishes the legal nature of the stop, whether you are being detained or are simply involved in a consensual conversation. Second, I invoke my right to remain silent. Speak this aloud. Remaining silent without verbal invocation is legally insufficient in many jurisdictions. You must articulate this right to ensure protection. Third, I want an attorney. State this before or during any arrest. Legally mandated questioning must cease the instant these words are spoken. Fourth, I do not consent to any searches. Articulate this clearly every single time an officer requests permission to search your person or property. Final critical guidance. Maintain composure. Remain courteous. Never use profanity. Never mirror aggressive behavior. Never attempt to litigate constitutional standards on the roadside. That battle belongs in courtrooms, not during traffic stops. But internalize this truth completely. Your right to record police encounters is not ambiguous territory. It is a clearly established First Amendment right, affirmed by 7 federal circuit courts, and explicitly supported by the Department of Justice. An officer demanding you disable your camera is either testing your legal knowledge or desperately hoping you lack it. You now possess that knowledge. This content serves educational purposes only and does not constitute legal advice. Always consult a qualified attorney regarding your specific circumstances, because understanding your rights represents merely the opening chapter.